am joined by Ryan Harris, a partner at Corporate Immigration Partners, and Ryan is going to talk about the National Interest Waiver as a potential alternative to PERM. But Ryan, before we dive into all of that, how are things going? How are you doing? Yeah, of course. Yeah, doing well, doing well. Nearing the end of April, May's coming up. Looking forward to Memorial Day weekend and all that good stuff. So yeah, I cannot complain. Ryan, for those who maybe aren't familiar with your background and your brand, can you just talk a little bit more about your career as an immigration attorney, as well as the work that you do with CIP?
Thanks for having me on today. I've been working in immigration law for over 10 years now. Started out as a paralegal. After law school, I actually spent a stint as a civil trial lawyer and came back to immigration because I missed it. It's a really positive area of the law. I know there are challenges and a lot of it can be painful for those going through the system. But as a practitioner, it's wonderful to work in an area of the law where really at the end of the day, you're helping people to realize their dreams and you're removing barriers. I've worked for companies large and small, very household names, very tiny startups. So sort of seen the gamut of challenges that come from big and small. Spent a lot of time working in the tech sector, but also with engineering companies, finance, so a range of different industries as well. Immigration is a really forever shifting landscape. We as practitioners are always looking for a better way, whether that be adoption of the latest technology or, that makes a program run smoother, more efficiently, or giving a fresh look to legal solutions like the National Interest Waiver that has really become more popular lately for a variety of reasons we'll get into today.
Awesome. Appreciate it. Well, Ryan, we will hop into that in just a second. You mentioned, the ever-changing landscape of immigration, which brings me to just a quick plug for Envoy Global's recently released 2024 U.S. Immigration Trends Report. We released this report last week, and we surveyed over 500 HR professionals across the country just to hear their sentiments and thoughts on the current landscape of U.S. immigration. Highly recommend you check it out to see the information in there, as well as benchmark your own corporate immigration program against those that are in the survey. In our first part, Ryan, which is the current challenges with PERM. So Ryan, I was thinking let's provide some context and background information regarding PERM. And just first question for you, what exactly is PERM?
Good question. That's a big question. But in its most basic terms, PERM stands for Program Electronic Review Management, which doesn't really tell you very much. PERM is really the process by which an employer proves that there is a labor market shortage, and that showing is required to provide a permanent offer of employment to a foreign national and then the green card that comes with it.
And correct me if I'm wrong, but there are a few main stages of PERM. Is that correct?
It is. So just to sort of summarize the phases of PERM, the first of those is working with an employer to define a job and its requirements. This then gets put into a pipeline at the Department of Labor through an online filing called a prevailing wage request. These take about 6 months to come back. So that's sort of first stage. What usually follows that, sometimes you do this at the same time, is the second stage, which is the labor market test, also known as recruitment. This involves internal notice to company employees, as well as paid media ads that the Department of Labor requires to advertise the job to the wider world. The company then, if there are applicants in response to those ads, need to consider those applicants. There's a good faith requirement here to really have this be a real sort of hiring process where you go through and determine whether there are any willing and qualified U.S. workers that are able to fill that PERM job. That's usually about a 2 to 3 month time frame. So from stage 1 to 2 might be as long as about 9 months. Once you hit the end of the recruitment period and you've proved in your labor market test that there is a shortage and there are no willing and able U.S. Willing and qualified U.S. workers able to fill that role, then you get to file the PERM application itself, which is also known as the ETA 9089 form. Historically, these have taken 6, 7 months, roughly has been a recent history example. Right now, they're taking 1+ years, like 13 months, 14 months in some instances. So it's been sort of painful to see that wait time drag out, which sort of feeds into why companies are starting to look at perm alternatives. Um, you know, why does it take a year? There are probably a lot of factors that go into that. Um, Resources at the DOL, political priorities. There is a lawsuit that's ongoing on this issue, and some of the discovery that's sort of publicly available in that lawsuit, I think, reviewed and showed that the DOL's position is it takes about 30 minutes to review a perm application and certify it. So you wait a year to get that 30 minutes right now, and that's causing some challenges. So if you put all that together correctly, it's well strategized, the recruitment and labor market test is successful. You wait your year, and out the other side of that process comes a perm certification. Then the next step is to file what's called an immigrant petition, otherwise known as the Form I-140. Once your perm is certified, this is basically a formality on the perm-based path, right? It's essentially guaranteed approval if your employee qualifies under what you as a company said the job requires in the perm filing, right? And so ideally you've thought that through from the beginning of the process. The I-140 you can think of as your ticket to stand in line for a green card, right? Green cards are limited by country of birth and by preference categories, right? Sort of job level categories, you can think of them. And that's your ticket to stand in line for the green card, to present that ticket basically once your number comes up and there's a green card that's available in your category. The backlogs and the lines that folks wait in can be extraordinarily long depending on your country of birth. These backlogs used to really only mean India and China as a country of birth. That's really where the backlogs were for a long time, and that's still where they're certainly the absolute longest. But these backlogs are now creeping into other countries and other preference categories because there are just not enough green card inventory for the talent demand that we have as an economy. And really that as a solution is something only Congress and the president can fix by putting more green cards on the shelves, right? So we can start working through some of these backlogs. So that's a big challenge on the I-140 and perm-based front, right? Is you're getting through all of these steps just to merely wait in a longer line. Important to understand that. Workers who go through the perm process are likely to end up in the second or third preference categories, right? Of the three main ones that we'd look at from the business immigration perspective. Whether you're second or third can depend on the degree requirements for your job. And if you're eligible for the second category, which we can think of as advanced degree, master's degree basically, or bachelor's and 5 years of work experience, if the job requires that, you are eligible to drop down into the third preference category. And this is important when we're talking about national interest waivers, because there's a limiting factor with those that it's important to understand if you as an employee or employer want to go down that path. And so taking a step back, what we look at if someone's got the second preference or the third preference category available to them, what I kind of use to describe this is the grocery store analogy, right? When you get to the grocery store, you see two lines, they might be different lengths, but there might be indicators there that one line is going to move faster than the other, right? Maybe in one line that looks a little shorter, there's 6 kids there, right? And they're causing a mess with the candy bars, and right, we think that's going to make the line move slower. And the other line, right, it's a lot of maybe senior citizens who are going to just move a little slower through that line. So we have sort of variables we can look at to see, like you're in the grocery store, okay, which line do I want to get in? And if you're on the perm-based path, you do have an advantage if you're a second preference case of being able to jump lines, potentially, right? If you see and you realize I picked the wrong one, the other line's moving faster, you have a mechanism by which you can actually jump into that shorter line. And that can be something that's valuable. You can never do that with a national interest waiver case. So before we even get into what national interest waiver is, if you have that understanding of perm and that sort of line jumping ability, that is something you give up if you go with the national interest waiver, because those are only EB2 cases, second preference category. You can never jump to the third preference category when you're talking about a national interest waiver case.
Where do the self checkout lanes factor into your?
That's the EB1.
There you go. No, thank you so much, Ryan, for that overview of perm. Quick question as sort of a follow up, but also a hypothetical, or just kind of want to pick your brain a little bit. So,
Mm-hmm.
knowing that this entire process takes a year plus, when you're talking with your clients, what are your best practices that you're talking about right now?
Well, let's before I jump into the best practices, let's talk a little bit about, because the challenges are a little bit more than the wait time, and that's like challenge number one probably right now is perm takes way too long, like longer than anyone would think reasonable. Now, sometimes that's just kind of annoying, but you have the time, right? You've got enough runway on your visa, you can wait out the process, even though it's frustrating and even though it's sort of anxiety inducing to have this sort of going on forever in the background. And sometimes that timeline is really disastrous, right? Sometimes you don't have the runway. Sometimes you don't have the time to wait for as long as perm takes. And the longer that timeline gets, the more people, right, fit into that more problematic category of the perm is really kind of dooming your chances to remain in the US. Um, Aside from the wait, which is significant, perm has a challenge of it being something of like a gotcha game. Um, it's mostly predictable, and this presentation is not to knock perm, right? Because we still do a lot of perms, and perm still gets you a desired result in a lot of cases. But there are a small minority of cases, and historically have been in the perm system, that get denied or delayed through what you can look at as shifting, kind of unforeseeable standards and issues that are brought to bear on these cases in the review by the Department of Labor officers. And so, related to the timeline problem, like if you have a perm that unexpectedly has an issue that you couldn't have foreseen because all of a sudden DOL has a certain issue that they're going to start picking on with cases that we couldn't have known about before, right? And that's setting you back on that timeline and making the issue take even longer. And if you don't have, again, that runway on your visa, that can be a big problem for you. DOL moved the PERM system into a new platform last year. There's a new form involved, and it's a new filing system online. We really haven't started to see those cases come out yet. So we're still just getting approvals now, wrapping up sort of what was left over in the old system. And there was a troubling Freedom of Information Act request that went out to the Department of Labor that said, hey, we as practitioners, we as employers want to see what your guidance is so we can sort of avoid some of these shifting standards and kind of invented rules. So can you show us what are your training manuals? What are your guidelines for adjudicating perms that are filed in the new system? Because we haven't seen them come out yet, right? So we don't have anything to judge by. And the troubling response to the Freedom of Information Act request was, we don't have that stuff because we haven't written it yet. So they're still hopefully now a little bit closer to that when this FOIA response was issued. But to be honest, and any practitioner being honest would say this, that there's really no reason to panic, but there could be some new issues that DOL is going to come up with in the new platform that affect cases filed since late 2023 that are just not knowable right now. So again, perm mostly reliable, but this is a drawback of the very long perm timelines. This sort of ticking time bomb effect of, do I know if there's a problem? And if I file a case, I'm not going to find out till a year later if there's a problem, and I've got to go back to square one. Big challenge with perm there. Perm recruitment, that second phase where we test the labor market and we look to potential applicants for the role. There are some drawbacks there in the sense that it can be expensive to an employer, right, as to the paid media that you are required to buy to advertise the role. One of the required forms of recruitment is you have to post in Sunday newspapers. And so if you take a look at your Sunday newspaper, you see a lot of perm ads there. If companies are to start looking at perm alternatives more, it's not going to be good for the newspaper business, but it could be better for the company's bottom line in terms of green card costs that are expended on these cases. It can be a lot of work for your HR recruiters, your GLOMO team who's involved in reviewing the applicants. Law firms are not allowed to do this work for you. Your service providers love to make this process as easy and painless as we can for you, but there are certain things in the recruitment process in terms of reviewing candidates and keeping with that good faith requirement to give everybody a fair shake who comes in the door and applies for the role, that you shouldn't have the external lawyers, or service providers doing that review work for you. So you've got to find the resources to do it in-house. The recruitment process itself has a sort of checkered history of inviting enforcement scrutiny on discrimination issues, on whether the company meets this, what can be kind of a fuzzy good faith requirement in some instances. If you are all working in this space, you have probably heard over the last several years of DOJ settlements with big household name companies that are really unique to the facts of those cases. So again, sort of not a reason to shut down your PERM case, but some troubling indicators of attitudes within the government, within the enforcement regime of how compliance is looked at with respect to PERM and recruitment and candidate review. I'd say on the other side of that, there is a case that involves SpaceX that's on appeal that could help in this space that all of us attorneys are closely watching. So if you don't, if you're not up to speed on the SpaceX case and how that could resolve some of this issue, that's something you want to be discussing with your legal team. There's a possibility in PERM of when things go wrong or when mistakes are made of pretty draconian Department of Labor enforcement. Things like supervised recruitment, where DOL sort of gets involved in how you're doing the recruitment, how you're communicating with candidates, things like that, that can be really onerous to deal with. So these are things that are not new necessarily. Some of it is more recent trend, but these are sort of long-term existing challenges with the PERM program that might cause a company to look outside of that space for some different alternative. So just to sort of wrap that up in the parade of horribles here with PERM, and again, this is sort of looking at the negative side, not to trash PERM entirely, but PERM is strict. So it's limited by location. It's limited by job. There are flexibilities you can build into a PERM case, but there are also strategic limitations in how flexible you can be. So this is not a great thing for remote work necessarily if you weren't set up that way in the PERMs that you were devising, right? Because if you have a PERM for somebody in California and that person relocates across the country to the East Coast, they don't have a PERM case, right? When their ticket comes up in that I-140 line and it's time to file for a green card, they're not set up to do that if their PERM is not cited in the right place. So for companies, this can lead to sort of redundant costs. And as we've seen the multiplicity of people moving around and being remote roving workers, it can be a difficult thing for the PERM, right? But it wasn't written for that remote workforce to keep up with. Again, PERM can be done fully remote. There are limitations to that. And maybe you've got PERMs in your existing inventory that were done, long before the pandemic and remote work became such a boom that it is now. So that can be a limiting factor in your PERM program as well. And then I'll sort of close off on the sort of list of negatives here. Is any company that has a PERM program that's gone through layoffs has seen the damage and the impact that this can have to an existing PERM program. It has, when layoffs occur, it's often right bottom line issues, budget issues, and immigration is not really top of mind necessarily. And so the impact to the immigration program isn't considered. So it can create sort of levels of crisis and panic among your foreign national population. If a PERM case, is ongoing for someone you've laid off, that can be really bad for the foreign national you've let go, who might not have enough time to restart and wait that 2-year basically process out. Maybe they're going to run out of time on their visa. And for your existing employees, they are impacted if they have a PERM potentially by layoffs at the company. It can create big delays. It can really kind of destroy cases and cause a false restart in some instances. So an unavoidable problem, right? Companies, nobody ever wants to do a layoff, but they occur. We've been seeing them more recently in the last year or so, especially in the tech space. And so that's been causing a lot of consternation as to PERM.
So, Ryan, with everything that you just laid out, let's move to the National Interest Waiver, NIW, as an alternative to PERM. Let's just start from the top again. What is the National Interest Waiver?
The National Interest Waiver, the waiver part of that is it waives the need to do the PERM. So you get to sort of short circuit that whole process, skip right to your ticket for the green card, right? So it's not going to get you to a green card necessarily a lot faster than a PERM if you're in a really highly backlogged country like you were born in India. But you're going to get through the PERM, get to the I-140 stage a lot faster. And the approval of that national interest waiver, I-140, is then travels with you, right? So if you move locations in your job, if you change employers, you're not going to have to go through that PERM process again. Now, sort of as we get into and dive deeper into national interest waiver cases a little bit, I want to also just call out there's a big elephant in the room here of elections that are coming up later this year, and a lot of what is happens in this space involves a really highly subjective application of discretion, and involves standards that have recently, I think we'll talk about, improved and gotten better for these cases, but would be very easy to turn around. So there may be a window of opportunity, basically, in the national interest waiver cases that may not remain open forever. So I think we should all just sort of keep that in mind as we look at it. It's not really a panacea, but in sort of targeted cases, it can be a really good solution. And I think everyone would love getting to skip PERM.
Well, skipping perm, how does the processing times for the NIW compare to perm?
So if you file an NIW case under regular processing, you're probably looking at like 9 to 12 months to get a decision on that, perhaps a bit longer. If what's known as a request for evidence is issued, maybe the government's not totally convinced by your first go, so you have to respond again, and then they get a few more months to decide that. So all told, could be longer than a year. There is premium processing available. So if you're willing to pay that cost, you can actually get the NIW case approved in 45 calendar days or less. The government, if they exceed the 45 days, have to give back the premium processing money, and they don't ever give back the money. So you're going to get that 45-day turnaround. Oftentimes, it even gets adjudicated in a shorter period than the 45 days. Again, you also have to tack on the request for evidence timeline there. So it's a much shorter one still, but if you file and say 3 weeks later you get a request for evidence, you're going to take some time to make that response. The government's going to get another 45 days to issue a final decision. So much shorter timeline on the premium processing route, as with other areas of immigration that can use premium. So you get to skip this sort of hot mess that I just described with PERM. The sort of dirty secret with immigration is like all of it is kind of a hot, irrational mess, and we're all sort of dealing with it as best we can in an irrational system. And so really just want to highlight, PERM in most cases does a really good job of securing what is a really critical life goal level benefit at predictable costs, if not, high costs. So it's still something you should have in your toolkit. There could be efficiencies if you're leveraging, a big PERM program that involves a lot of employees that would be hard to get away from. But the national interest waiver, again, in sort of targeted fashion, could be a really good solution. For an employee, employers, there may be concerns here about sort of double cost or employee retention. One way to look at this is if your employee already has an I-140 approval, right? If you've already put them through the PERM process and already have that ticket to stand in line, they don't really need the national interest waiver case. Now, there might be reasons it could still be beneficial that you want to talk about, but the need is not as great there if you've already made it through the PERM process. An employee might still want it, and employees are really free to self-petition for this. And that could be a way where they're financially supporting it themselves or where the employer is backing that up. But the employer is not necessarily the legal sponsor of the petition, right? The PERM can't be done without the employer. PERM can't be paid for by an employee. So there are strictures there in the PERM program that don't exist on the national interest waiver side of things. And so characteristics of the case might vary, where an employee sort of comes forward and wants to take charge and move forward with their own I-140 on their own initiative. But there can be a mix there, basically, of employer versus employee sponsorship. I've heard sort of expressions of concern about, well, if the employee gets the I-140, are they just sort of free to move on, and what's going to keep them invested in the company? Well, if the employee presents a good NIW case, one of the way to look at this is sort of generosity and immigration benefits and options is itself a retention tool for an employer. And employees who want to leave will leave. Sort of any tethering that you get from a PERM process that's locked into a particular employer is very temporary at best, right? People change jobs having gone through the PERM process all the time. So might be a way to think about cost support for that, for whether in individualized cases, or whether or not you want to have a policy as an employer about what are the circumstances in which you provide the sponsorship, and what are the circumstances in which you'd encourage the employee to sort of go for the I-140 on their own. Again, not allowed in the perm space. So if you're the employer, you have to be the sponsor, you have to pay the bills.
What are the eligibility criteria for the National Interest Waiver? And are there any limitations?
Uh, there are. So when we're looking at the profile of who makes a good NIW case, right? And you can set up a sort of screening mechanism with your legal services provider that can help sort of normalize this in your program. But basically what you're looking at as a first threshold question of, remember, National Interest Waiver is EB2, it's second preference category. So that's the first getting through the door before we get to the national interest part. Is, does the person have the credentials for this? And EB2 means a master's degree, or a bachelor's degree plus 5 years of experience, or exceptional ability. And exceptional ability, there are a variety of ways you can show that, but most of your cases that are going to be in the national interest waiver space are going to qualify through the kind of more easy, more clear-eyed standard of either has the degree or doesn't, right? If someone's got a bachelor's degree and less than 5 years of experience, and you still want to consider them for the national interest waiver, then you're sort of stuck with the exceptional ability standard, which can be a little bit more loose and more subjective. And so an attorney can look at the profile of the case and let you know if they sort of meet uh, that exceptional ability standard. But if you have the master's degree, if you have the bachelor's plus 5, you don't have to deal with the exceptional ability requirement. I think that can be sort of a confusing thing about this space, is it's not a must-have in an NIW case. So once you get past that, right, and you're through the EB2 door because you've got your master's degree, then your North Star is what's called the matter of Danisar case. That is a decision that came out that provides us a 3-part test that's been fleshed out a lot more recently by the updates to the USCIS policy manual. But the policy manual sort of dresses up the framework that Danisar gave us, that there are 3 criteria that you got to meet. The first of those is that your endeavor, what you're working on in terms of your national interest waiver case, has both substantial merit and national importance. Okay, some of that speaks for itself. If your company made a COVID vaccine, right, you don't have to say a whole lot about substantial merit and national importance. If it's something that's less clear, it's not a defense or counterterrorism or public health related item that really is just intuitively aligned with national interest, we look to the government's own statements. So there are policy memos, strategy plans, legislation even, right? The CHIPS Act that just has gone into effect, highlighting the national importance of having a microchip manufacturing in country. The president's executive order on artificial intelligence is another sort of hot topic, right? What that does is calls up the importance, or the president himself thinks that this is an important area that people, that we need to have scientists working in to drive forward with our national strategies. There is something that everybody looking at a national interest waiver should be reading, and that is the White House critical and emerging technologies list. There is a lot of IT area in that list. So if you're working in tech, I think sometimes folks look at this question the wrong way, and they say, well, our company sells shoes, right? How's that the national interest? Our company does like social media or for gamers, like, doesn't pass the laugh test. But what I'd say to that is, don't sell yourself short as a company. Really, this is about framing, right? So even though you make video games, there might be some data science or some AI research and the science that underpins your product or the service that you're offering that has been identified and recognized as a national priority to make advancements in. So you don't have to be a defense contractor, basically. So if you're thinking, we don't do national interest waivers because we're too soft, as it were, that might be the wrong way to look at it. So make sure you're talking with, if this is a tool you want to put in your toolkit alongside your PERM program, of how would we talk about the work that we do, or that our sponsored employee is doing at this company, that we could talk about in terms of it being aligned with the national interest and what the national priorities are based on any of these sort of government statements. And there's a lot out there that you could draw from. So that's substantial merit and national importance. Once you have that, right, we're in an area of national interest. Okay, that's the first green light. Then we've got to get through the second two lights. You got to be well positioned to advance the proposed endeavor. Now, what does this mean? This is now the focus goes from what are you working on to what about you as an employee can you bring to the table, right? And this is going to be different in every case. So you want to think about what mentors have you worked with that you could draw from who might write a letter to talk about the important work that you've done in this field? What projects have you been a part of, even as a student, right? Even if you've not been in the field for very long, what projects have you done with professors at school or with student groups that have led to some kind of tangible outcome that we can point to say, this person is well positioned and the country needs them in this position in order to further the advancements in this field. And so that's, again, going to be very different for different people. This is not the EB1 extraordinary ability standard that we're talking about here, right? So that I think is often conflated. And I think part of that is just the history of this is we as practitioners, because this has always been a subjective standard and it's sort of up to whatever some, roll the dice and whatever officer's desk you land on at USCIS, are they going to think it's good enough? And probably more cases were turned down in the past than would be advanced today. And that really is because of the current and updated policy guidance in the USCIS manual that goes to great lengths, especially when we're talking about STEM fields, of how you can prove these elements. And so if you went to an attorney 5 years ago and said, can you look at my profile for National Interest Waiver? And they said, I don't think you got enough to make it. It might be time to ask again, right? Because these standards are more fleshed out. They're more coherent. And we see that in the cases that get filed in terms of, right, an EB1 extraordinary ability standard being out here, right? Everybody loved to be an EB1. Those are really hard to prove. A lot of those cases, in profiles I look at where people come and say, I'm India born. I can't wait 100 years for this green card to come through. Can you look at me for EB1? And unfortunately, the answer is often like, you don't meet the standard because the standard is so high, right? Different standard here. We're talking about well positioned to advance, right? It can be more incremental than we're talking about for extraordinary ability. Now, the last and final prong here, we're through the first two green lights, is you got to prove to the government that it would be beneficial to waive the PERM requirements. Remember, the whole reason we're here, it's National Interest Waiver. What you're waiving is the PERM step. And it's a big step to get waived past. And so this is a little bit more of the esoteric prong, I would say, requires somebody who really understands what USCIS wants to hear on this and sort of the language to speak in order to make the arguments. But there's some overlap here, right? There's some overlap with the greater the national importance of the area, the more beneficial it is to waive the PERM requirement, right? The more well-positioned you are to advance that endeavor, the better your argument is. We just need to get the PERM out of the way so we can get this person to work and get them a green card, right? So that's, in a nutshell, the three tests you need to make.
You mentioned just name it again, and I think we have a link that we could paste in the chat. But this stemmed from there was a specific name you mentioned at the top for it.
The Critical and Emerging Technologies list.
Critical Emerging Technologies list.
We'll
But then
the matter
of
Danisar case as well. Just sort of core reading to understand how we came up with this National Interest Waiver test, right? Because it's not defined in the statute. It was the case that sort of set the stage for this. So if you're interested in understanding that background, it's an important document to read, and we'll link this in the event chat.
Yep. Let me paste that right now, actually, since I got it open. All right, so just pasted that court case there that Ryan has mentioned. So, Ryan, it sounds like so you mentioned all this great information. Is it wrong to say then that NIW petitions are maybe more common for some industries / jobs compared to others?
No, it's more STEM. USCIS has data on this. The recent USCIS data that was published, actually, we're going to post that in the chat as well, so you can take a look at the numbers for yourself. But that data does, I think, show a bias for STEM fields. Now, that's not to say if you are in a non-STEM field that you can't get a national interest waiver. As long as you can make the arguments that you are working in an area of national interest, right? And the critical and emerging technologies list, probably that's not your hook, right? Because that's going to be more IT fields. So find another national strategy document, white paper from the White House, executive order that talks about the importance of various areas. And that could be business, marketing, sort of softer, more liberal arts studies areas. I think you just have a tougher hill to climb, and it's less intuitive probably to these adjudicators of how that ties in, because it's not the case that they may be most used to seeing. But it's certainly not a barrier to applying. It's STEM not required, but probably more common.
Are you aware of just any chatter going on about utilizing NIW more? You mentioned you brought up the CHIPS Act, which the government is providing subsidies for large corporations, Intel, Samsung, et cetera, to build these massive factories in the U.S. But I believe a few months ago, there were a few articles about just the shortage of high skilled labor. It's very, very high skilled. Do you foresee scenarios where maybe government, in combination with employers, work to utilize NIW more to bring that highly skilled talent to meet the needs of this legislation or other initiatives from the government?
I think it's happening now, and I think, right, the big question is like how much and where exactly the standard landed in the latest updates. And the big question on the mind of somebody who's got an ongoing PERM program, but it's just the inertia of moving from one approach to another can be difficult. And really, what I think employers want to hear is, well, is it reliable? Is an NIW going to be a reliable alternative to a PERM? Right? If it gets approved, no PERM. If the NIW gets denied, you still can do a PERM, right? You don't have to necessarily choose one or the other. This is, right, if you've still got time on like your temporary H-1B visa. But you want to know that you have a strong case before risking the additional investment, because as an employer, great legally that I have the option of filing a PERM after having an NIW that goes down unsuccessful, but don't love the idea of paying for both. Again, referring back to the employee, if this is really an employee-driven request, can be part of the cost equation there. In January 2022, that's when USCIS updated its policy guidance to clarify how certain professionals, especially those in STEM fields, can show eligibility for the NIW. In January 2023, they added the 45-day premium processing option, right? So now it's more clear how to get it. Maybe it's a bit easier to get than we thought before, and now we can get an answer really fast. Okay, so what happened there, it was followed by an increase in EB2 filing. So from fiscal year 21 to 22, and this will be in the numbers of the USCIS document that we'll post that you can take a look at, the total receipts of all I-140 EB2 increased 20%, and it was 10% the next year. Approvals from 21 to 22 went up, and this is all EB2, including NIW, went up 60% and then decreased 12% in the following. So 21 to 26% NIW filings, and the total EB2 shoots up to 43% in fiscal year 2023. So almost doubles the proportion of NIW cases that were filed. And I think that's driven in large part by the updated guidance, by the availability of premium processing, and by that getting out into the ether that, hey, NIW is maybe a better option than folks thought it was historically. So doubling of those numbers, there's some drop then in the non-National Interest Waiver filings, so your PERM-based EB2 filings. And maybe that's because those cases that would have been filed EB2 and PERM switched tracks, right, and jumped over to the NIW. So what's kind of the insight from these numbers is, as the word got out that the bar might be lower, more cases were filed, and maybe some with weaker profiles that were ultimately denied. So the approval rate for NIW in 2018 to 2022 hovers between 85 and 90%. So that's pretty good. Let me take a stop there, though. Does that mean if anybody who applies has a 90% chance of getting one? No. This is a self-selected group, right? So this has been screened likely by attorneys, and by employers, and they've picked strong cases to go in. And sort of what does strong mean is the level that I think everybody's still looking to define, and we're learning that through the cases that we file. But so 85 to 90% in that range of 2018 to 2022, high approval rates. 2023 approval rate drops down from 90 to 80. Most companies would not be happy with an 80% success rate given the money that gets poured into the case, right? You want something a little bit higher than that. So more insights to draw from that. Like I said, approvals are already high due to self-selection. The profile evaluation is changing with the adjudication trend, right? How we see the strength in the cases as attorneys is changing as we see cases come out, and more of them be more successful. But perhaps there was maybe a drive to become too aggressive, leading to more denied cases. We have this uptick in the denial rate, right? So we're finding where that bar is, and probably will float back to 90% at some point is what I would expect as people identify sort of where the bottom is and the strength of a case that you can get approved. The denial rate, I'd say, is higher if you break out the non-STEM cases. And this is sort of this bias for STEM that I was talking about. So probably more risk if you're going in a non-STEM field. So you want that case to be really strong on the grounds of, right, if they're well positioned and how important is the area of national interest and how closely we can tie their work to that area. You want that to be, I think, super strong if you're going in a non-STEM field.
Right. Do you feel like it's necessary for an employee to have a PhD / publications, etc., to have a strong case for the National Interest Waiver?
No, I think those items can help make a really strong case, but not required. Often sufficient, but not required.
So, Ryan, you mentioned, I think just want to pick your brain a little bit more, and just hear your insights as well as, practice pointers on how might HR teams seek to utilize NIW?
So I'd say first off, make sure you're considering it if you've got, and those who've dealt with the situation will know exactly what I mean when I say an H-1B max out situation, right? So H-1B, you get 6 years to start. If you hit certain milestones in the green card process, that unlocks for you as the employer the ability to continue extending the H-1B for as long as you need to, might be decades in some cases, until you get to green card, right? So if PERM timelines or a mistake in a PERM or a bad decision on a PERM, the appeal didn't work, and you're stuck with the situation where you're running out of time on the H-1B and you don't have time to go through the full 2-year life cycle of the PERM again, it's something you want to talk about as your Hail Mary, right? If there might be an NIW case, maybe even a weaker NIW case that you might want to try if we're trying to pull out all stops and avoid having to either let the person go or offshore them to wait for that PERM process. So that's sort of one area where even if you're not looking at standing up an NIW program, is making sure you're thinking about it in the max out scenario, and that's something your practitioner can walk you through. If you want to think sort of bigger picture, updating your policy on green card assessments and approvals process, right? So what it looks like now is you might have a policy that says, well, we start a green card after 6 months or after 1 year of the person being onboarding with us. That by default for many companies for a long time has meant green card equivalent to PERM, right? We start the PERM because PERMs are what we do. Maybe you want to insert a assessment or a screening mechanism at the start of that process to say, we're ready to start a green card, like the person's in good standing, they've been with us long enough. Do we want to go PERM here, or do we want to go National Interest Waiver, or maybe some other alternative? Right? National Interest Waiver is not the only alternative to PERM, but it's the one we're talking about today. So, you can put that into your policy that, like, we will make the assessment as the employer, what's the most advantageous path to take, and then what your cost support will be for that. Elections, again, can have a big impact here. So make changes. If there's changes to the policy, you might want to make them tentative. We're going to see, where this takes us. And that's not to say that I know or anybody has a crystal ball can say if the election goes one way or another, exactly what will happen in National Interest Waiver, right? Maybe nothing. Maybe that policy guidance doesn't get touched, but maybe it does. And that could be true under any number of election outcomes, right? That there could be changes to how these cases are decided But for right now, it seems to be a more favorable time historically than in years past. So nothing is stopping you from today asking your attorney to assess for either national interest waiver or PERM. If the NIW is pursued, make sure you have a contingency plan that addresses the cost question and what's going to happen, because it is a subjective case if we lose, right? You cannot ask the employee to cover the PERM if you try the NIW first and it fails. So cost is a big sort of factor in there. Will we pull out all stops? Is that sort of the type of program we're running? Is, if the employee wants to go for NIW and the attorney thinks he's got a shot, will we support that? Or is it going to be more limited use, right? This is all questions that you can use to build into your existing policy.
Ryan, Ryan, if I'm the HR, and I'm working with you, when I'm looking at my green card policy, do you think I should have NIW fall under that or be like a separate bucket?
I think if you haven't thought about it, you should. But it might be separate, right? It might be more targeted. It really depends on the program, the profile of employees, the sort of work that you're doing, the educational background of the folks you're hiring, and whether or not you make good cases, right? I'd say if you're a chips manufacturer right now, you might be doing all NIWs. And that's maybe an exaggeration, but it proves the point I'm making here, that it depends on your program. So it's definitely a conversation you should be having. Time to dust off that policy and take another look at it.
As we look to wrap things up, any final remarks, final thoughts, anything that maybe we didn't hit on?
And just thank you very much for the opportunity to come and talk about this today. It's an expertise that is shifting, as much with immigration, right? Like I sort of started out talking about, it's a shifting landscape, and you always want to be open to where the conditions are going, and whether that's the tools you're using to file cases and collect information, or the legal strategies that you're undertaking based on changes in attitude in the government. And especially when it's something as subjective as a national interest waiver, it can create a space that is not so obvious on the surface, right? The government never came out and said we've got a new standard for national interest waiver. They simply elaborated on existing policy and existing case law. And so if it can benefit you, you should be leveraging that to your advantage and for the advantage of your foreign nationals and your program overall.
Well said. If you'd like to learn more about Envoy Global and corporate immigration partners, head to envoyglobal.com.